The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court.
Thank you and good afternoon. Welcome to the North Carolina Court of Appeals. I am Judge Allegra Collins. Sitting with me today is Judge Fred Gore and Judge Darren Jackson. Our clerk today is Mr. Eugene Soar. We also like to thank Mr. Fred Wood and Mr. Ziad Haq in our IT department for making this remote argument technically possible. We have one case on for oral argument today, State v. Daw number 20-680. Counsel for the appellant, you've indicated that you would like to reserve 5 minutes for rebuttal.
That's correct, Your Honor.
All right, thank you. Counsel for the appellant, are you ready?
Yes, Your Honor.
All right, please begin.
Thank you. May it please this court. As this court well knows, for the past year, our state, our country, indeed our world has been upheaved by a global pandemic that is historic and unprecedented. For Mr. Daw, this threat is all too real, given his severe respiratory illnesses and his confinement in prison. However, the issue before the court today is not about Mr. Daw's condition or DPS's response or lack of response to COVID-19. When distilled down to its most basic premise, this appeal is about Mr. Daw's right to be heard and to present his evidence and his case before a tribunal, nothing more and nothing less. When the habeas court summarily denied his petition, it denied Mr. Daw such an opportunity, contrary to our federal and state constitutions, North Carolina statutes, and this court in the North Carolina Supreme Court's precedents. I'll start with the statutes. Well, it appears at first blush that 1742 would deny habeas relief to someone who committed or detained by virtue of the final order from a civil or criminal court. This statute cannot be read in a vacuum. The entirety of Chapter 17 must be read as a whole. 1742 conflicts with 1733 and the evolving jurisprudence of the Great Writ. 1733-2 specifically carves out an exception, where though the original imprisonment was lawful, yet by some act, omission, or event, which has taken place afterwards, the party has become entitled to be discharged. Even if this court were to give credence to the state's argument that 1733-2 only applies to civil matters, these are limitations for civil matters only. A person subject to civil confinement can be discharged only in one of the following. Thus, for those in civil detention, these 6 enumerated limitations are the ceiling. They are the only reason that someone in civil confinement can be released. But these limitations on civil habeas should inform this court that these limitations are also ones that can serve as a basis for habeas in criminal proceedings and judgments. For those habeas petitions, these limitations in 1733 are the floor, not the ceiling. 1733 specifically says, if no legal cause is shown for such imprisonment or restraint, or for the continuance thereof, creates the broad stroke by which someone subject to a valid criminal conviction may challenge such ongoing detention, even making such a challenge to the continuance thereof based on the 6 enumerated circumstances listed in 1733. Because again, these are the floor for criminal matters, but the ceiling in civil matters. This court has repeatedly found the same. Matter of Stevens, Hoffman, Freeman, and Leach. All of these cases considered 1733-2 and an after occurring event or omission in determining that when a liberty interest is at stake, that a person subject to a valid criminal conviction could in fact avail themselves of such a provision to challenge their ongoing confinement. Now, going back to the statute, 17.4 specifically mentions both civil and criminal jurisdiction. It would be contradictory for 1733 to say that someone in a civil proceeding under a valid judgment, as enumerated in 17.4, although some act or omission for a civil proceeding would be able to utilize 1733, and yet someone subject to a criminal conviction would not be. 1732 further buttresses this interpretation. 1732 speaks to proceedings upon a return and specifically mentions where the return has been upon commitment for any criminal or supposed criminal matter. And if issue be taken upon those material facts in the return or other facts are alleged to show that the imprisonment is illegal, then the court needs to hold a hearing. And on to our case law. In re Harris in 1954 is a clear example of where an after occurring event allowed habeas to proceed. Now, in that matter, it was a civil commitment for someone who was in a mental facility.
Can I just stop you real? I just want to clarify the scope of your argument. And you clarified in the beginning, but I just want to make sure that I understand what you're saying. Your sole argument today is that the trial court should have heard this petition to determine whether COVID is an event under 1733. You're not asking this court today to determine if there's an event under 33-2. You're just asking us to send it back to the trial court under 33-2.
That's correct, Your Honor. The sole argument is that Mr. Daw should have had an opportunity to be heard, to present his arguments, to present why this possibly could be cruel and unusual punishment. Now, I would argue there's almost a prima facie, could be a prima facie finding of that. The fact that Judge Rozier, just a week prior to Mr. Daw filing his petition for habeas, had found that DPS had violated the Eighth Amendment in its treatment of prisoners in the ACLU lawsuit and the writ of mandamus that was before him, and that was just a week before. But I'm not even arguing that even those findings by Judge Rozier necessarily apply to Mr. Daw, because each individual needs to be taken precisely as an individual. Each person's particular and unique circumstances need to be heard and need to be considered. So
that does bring me to a follow-up question then. So should this court determine that 1733 is applicable in this situation, then every habeas petition must be heard individually, based individually on the circumstances?
Well, no, I think that would actually, I think there's a gateway there. And I think that gateway was referenced in not only referenced, but it was the basis for the denial in State v. Leach. So I think State v. Leach provides sort of a gateway lever where if there isn't a basic premise, if there isn't sufficient medical conditions or anything else, I think that's where Leach plays an important role as a gateway. And because there just isn't sufficient findings for this particular individual, and a judge may deny under 1744 as opposed to 1742. And so in some ways, I believe 1744 provides that gateway. But at the same time, and I think in Mr. Daw's case, his respiratory ailments are of such nature and so well proven, and even in the findings of facts by Judge Kroom in this case, that it is clear that his particular situation, and even especially given the nature of his crime, they were non-violent in nature, and his sentence was only for 2 years. And so I think 1744 is a good gateway where judges can look at the initial presentation of what might be argued, and then they can use that, much as the court did in State v. Leach, to have that sort of gateway prior to having a hearing.
Mr. Mello, I'd like to ask you a question to follow up on that 17.44 issue. In Leach, the case was ultimately disposed of as you're requesting, considering 1733, but because there was some paper not included in the file showing, I guess, that Mr. Leach or Mrs. Leach had not exhausted their administrative remedies, it was denied for 17.4 for. Has Mr. Dahl exhausted his administrative remedies in that? There's nothing in our record to show us that he has applied for the ELC program. It was mentioned in the record, but there's nothing that shows that he applied for it, nor he had been denied. So could we just return the case back under the Leach framework as well?
Well, Your Honor, there is no application for the ELC program. DPS has specifically said this isn't something you apply for. It is something that we grant of our own discretion, and we take the initiative to decide whether we're going to place you in this program. Secondly, what Mr. Dahl did was he filed a grievance asking to be considered. Now, that is in the record that he was denied, that he filed that grievance and he was denied. But in the sense that he's exhausted administrative remedies, there is no administrative remedy for someone, at least in the current DPS policy, asking to be released and sent home. So in that sense, there is no exhaustion of remedies.
And if I could just ask you one other question, not really
Sure.
related, but I don't want to interrupt you several times. But I'd like to hear from you on the mootness aspect of this. You filed this, you asked for an accelerated schedule, of course, that the court granted. But I think things have changed since Mr. Dahl originally filed his petition, whether that's in the DPS or the vaccination. I mean, or his release date. And I just kind of wonder is his release date still what it was? He's still in jail, and he hasn't gotten a vaccination or anything that would make this case moot.
As of this morning that I know of, he has not received a vaccination. I believe, if I read the guidelines from the Department of Health and Human Services of North Carolina, I believe he would be a Category 3, possibly a Category 4. And I think we're somewhere right at the beginning of Category 2. So that could be a while. And then in regards to DPSs, I would only mention that when we filed the motion for expedited hearing, Judge Rozier once again in December had to appoint a special master because DPS just simply wasn't meeting the requirements that he was imposing through his injunction. And so in that regard, but it could be possible that if this court remands it back, that things have changed drastically. But that would be for a judge to decide. But I would also argue that I would think the public policy exception, given that there are variants to COVID coming forward, we don't know what's going to happen with those. Are the vaccinations going to be sufficient to ward off any variants of COVID-19? We could be very well back, just keep going in this vicious cycle. And so in that regard, I think the public policy exception would potentially come into play, such as in Chavez v. McFadden.
Counsel, I have a quick question from the standpoint of, I think it comes down to the very last phrase of 33-2, the party has become entitled to be discharged. Where is the cutoff for the determination of when someone has become entitled to be discharged? I know the argument is that because of the exposure, it raises to the level of cruel and unusual punishment. But where is the cutoff? What else gets us there outside of that? I'm trying to kind of compartmentalize and think about other scenarios that would help me process COVID getting your client to that threshold.
I'm not quite sure I understand the question, Your Honor. Are you asking?
Let me clarify.
Yeah.
The allegation, the exposure of COVID rises to the level of cruel and unusual punishment. What else would be a scenario that would rise to the level of cruel and unusual punishment that would warrant, this is unprecedented. So, we've never run across this. What else that you could argue that this court could evaluate would also get to that point? Give me a scenario and some other examples.
That's not COVID-19.
Exactly.
Okay. I think courts, if you look to Plata v. Brown, the U.S. Supreme Court case. Now, I didn't talk about that in my brief, so I'm bringing up like a case, but you're asking me a sort of a hypothetical. But I looked at Brown v. Plata and those lines of cases out of the Supreme Court, and also the district courts, some of the case law that I referenced there. But Plata v. Brown was a clear constitutional violation under the Eighth Amendment. Now, that was a mandamus action, but it was a mandamus action that ultimately resulted in the release of many people in California because of prison overcrowding. And I believe there was a similar situation out in Arkansas as well. And I believe that was Hutu out of the Supreme Court as well. I might be misremembering that case, but it is another Supreme Court that was in our brief. And so, yes, there can be conditions of confinement. Now, interesting enough, in Plata v. Brown, Scalia in his dissent talks about, all of the conditions of confinement for this particular individual, and there he was particularly talking about medical care, may be unconstitutional for this particular unique individual. They may not be so for somebody else. And I think that's informative to this court in the sense that, one particular individual under certain conditions might be having their constitutional rights violated. There was a case of a transsexual I believe in the DC court that addressed that particular unique individual. So there might be some unique personality or trait of someone that might make them particularly vulnerable. But again, I think those kinds of Eighth Amendment violations, et cetera, come down to the individual and come down to their unique situation. I hope I answered your question as best I could.
So I want to clarify, and I'm going to jump back to 33.2 and specifically point to the word event, that has taken place afterward. And if I correctly understand your argument, it is not COVID in a vacuum, but in this case, it is COVID plus pre-existing conditions plus DPS's alleged inability to, I guess, do what's needed to be done to ensure safety. It is all those things together that is the event. Is that what you're arguing?
Yes, Your Honor, precisely, because I think, I'm not arguing that, someone's confinement should just be so readily thrown out and allowed them, released to be home. I don't think anybody agrees with that. And so there has to be some gateway, some findings that show us why this particular individual, what is unique about them that they should be allowed to be released from their confinement. And so, yes, I think all of those factors should play a role. And certainly we'd be ready to present those if this case were to be remanded. And so, I'll go back to the case law and talking about that. State v. Cannon was another case, but this was in 1956, and I think that's sort of where we start to see the evolution of writ of habeas moving beyond simply prior to a conviction in a criminal proceeding. In State v. Cannon, the Supreme Court of North Carolina specifically alluded to a superseding event being a premise for habeas. Now, in that particular case, it actually wasn't even an issue, but in their holdings, they went out of for whatever reason, they just thought it was important to mention, well, there might be a superseding event for which a habeas might be a reason. Now, I don't think that was necessarily done in a vacuum, because in 1956, things were starting to evolve in regards to due process, in regards to people's confinement, conditions of confinement, and how they're being treated in jail. And so this evolution of the courts in North Carolina Supreme Court in that particular case starts to show that evolution of the writ of habeas beyond its original sort of thoughts. But we also, like I mentioned, in matter of Stevens and Hoffman and Edwards, Freeman and Johnson, I think, is particularly telling. If you look at the procedural history of Freeman v. Johnson was originally denied on some jurisdictional issue. I can only glean this from the procedural notes on the case. It was originally denied, taken up on writ by the Court of Appeals, and it was remanded back for a full hearing. So it was initially denied, much like Mr. Daw, summarily. But then the Court of Appeals sent it back and said, have a full hearing. And then after that hearing, it was denied again, and it was sent up on another writ of cert, and the full matter was heard in regards to, was this a superseding event? And I think in that particular case, it was the court decided that it was a jurisdictional issue for DPS, and it was an administrative matter, and not something for the court to decide. And so in that regard, I think Freeman and Johnson shows the precedent of this court, although it wasn't in the holding because it was already up after a previous remand. But I think it shows that this court is inclined to send these kinds of issues back where Eighth Amendment issues are being contested and being argued, to have a full hearing, to have someone be able to present their evidence, present their arguments, present their testimony. And obviously State v. Leach just clearly spells out going out of its way in its holding to say, we're not denying this on 1742. We're denying this on 1744 because of 1733. And so because 1733, that there may be an event or an omission or something that occurs post-conviction, and where a liberty interest is at stake. And this liberty interest is something that is opined in matter of Stevens and in Hoffman v. Edwards, Freeman v. Johnson, and State. All of these cases talk about that liberty interest and the importance of that interest and the right to protect that interest, and hence the right for someone to be heard. And so the writ of habeas has evolved in our jurisprudence. But as Amicus points out, other states with a very similar statute to ours, where there is an initial restriction, and then it talks about an after occurring event or omission or something else. Oregon, Idaho, California, or Missouri are some of the states that are mentioned in Amicus. They too have found that Eighth Amendment claims are a proper claim for challenging through a writ of habeas the initial conviction. Other states which don't even have an exception clause, I'm going to call it, have found that the Eighth Amendment right to cruel and unusual punishment and the conditions of confinement being challenged through the Eighth Amendment alone, without any exception clause, are of such great importance that those supersede any restriction on a writ of habeas due to a valid conviction.
I want to ask a quick question that really it goes beyond your argument, so forgive me, but I noticed in Amicus they talked about lots of different courts have sent it back for hearing. Has any court actually granted relief?
For
actually
specifically, or
exactly? Mm-hmm.
That I do not know. I mean, when we were briefing this thing, this was, and I didn't do the amicus, so I didn't do that research. But when we were doing this back, briefing this back in September, this was very, very early on in
Sure.
these cases going through. So I haven't gone back and looked. Yeah, so I simply don't know.
Okay.
Yeah. But as I was saying, even in amicus, we see that conditions of confinement through the Eighth Amendment, even without an exception clause, is sufficient to overcome any restriction that a statute might come. Why? Because it's a constitutional claim, and they're not necessarily striking that clause from the state statute, but they're simply saying this Eighth Amendment issue supersedes it. And this is Pennsylvania, West Virginia, Utah, Kansas, New Mexico, Georgia, New York. And so this use of habeas for conditions of confinement is this, we're not asking the court to go out on a limb. This has been something that's been repeatedly done throughout the history of the jurisprudence of all the states and in the federal circuits. And so this is nothing new. We're simply asking you to continue to follow the case law and the precedent that this court and the Supreme Court of North Carolina has established over the last 50, 60 years. And so I think I'm going to close there for now, and I'll save my last few minutes here for the end, unless there's any questions.
No, it doesn't appear so.
Okay.
Thank you. You can
Thank
save
you.
the remainder of your time for rebuttal. Mr. Hyde, are you prepared to proceed?
I am, Your Honor.
All right. You may.
Thank you. May it please the court, my name is Joe Hyde. I represent the state in this matter. This case is before the Court of Appeals on the Court of Appeals grant of defendant's petition for writ of certiorari to review the trial court's order denying his petition for writ of habeas corpus. The issue in this case is whether state habeas is the proper vehicle to obtain relief from the threat of contracting COVID-19. Look, nobody's denying that COVID-19 is a very dangerous disease. Nobody is disputing the fact that it has cost thousands of lives in North Carolina, both those that are incarcerated and those that are not. So I don't want anything that I say to be taken to downplay that threat or to suggest that it's not a dangerous condition. It absolutely is. But at the end of the day, this case is not about whether some other state's law provides for relief on this kind of claim. It's not about whether this defendant can obtain relief on a federal petition for habeas corpus. Opposing counsel has suggested that it's about the defendant's right to be heard, but he himself recognizes that there's an ongoing litigation in the case overseen by Judge Rozier. That is a defendant's opportunity to be heard. If the defendant has a valid complaint that his constitutional rights are being violated, he can bring a civil suit. He may not assert that claim in a state petition for habeas corpus. As our Supreme Court stated in Palmer, the only question open to inquiry is whether the judgment is warranted by law and within the jurisdiction of the court. State v. Surratt is a case in which the trial court denied a petition for habeas corpus, finding that the trial court had jurisdiction over both the petitioner and the offense at the time of his trial, and the judgment was authorized by law. Our Supreme Court said, upon this finding, the trial court properly denied the petition for writ of habeas corpus. That is precisely the same thing that happened here. The trial court found that the judgment entered against defendant was entered by a court with competent jurisdiction. It was a valid judgment. Therefore, under State v. Surratt, the trial court did not err in denying defendant's petition for writ of habeas corpus. In fact,
I want to ask a quick question. At the end of your brief, you state that that appellant has not preserved for appellate review his constitutional argument.
that's correct, Your Honor.
Can you elaborate on that? It seems that his constitutional argument is part and parcel of his habeas argument, and that in the trial court denying habeas, he necessarily ruled upon that, and therefore it's before us.
Under Rule 10, in order to preserve a claim, the constitutional issue has to be both raised and ruled upon. The trial court in this case made no findings or conclusions about the constitutional issue. As I think opposing counsel will concede, the trial court sidestepped that issue entirely and denied the habeas petition on the basis of 17(4) sub 2, which says that a habeas petition should be denied when the person is detained by virtue of the final judgment decree of the competent court of civil or criminal jurisdiction. So because of the grounds that are specifically provided in the trial court's order denying the petition for habeas on the basis of 17(4) sub 2, there have been no findings or conclusions on any alleged constitutional violation. Under Appellate Rule 10, it has to be both raised and ruled upon. There's been no ruling on a constitutional claim, so it's not preserved for this court's review. So those provisions in Palmer and Surratt have been codified and memorialized in 17-4 and 17-34 that say that if it appears that the person is detained in custody by virtue of a final judgment or decree of any competent court of civil or criminal jurisdiction, relief on habeas has to be denied. That's what happened in this case. I don't think there's even been an allegation that the trial court that entered the judgment lacked jurisdiction. So we have to look at 17-33, because from the very beginning, defendant in his habeas petition, defendant in his brief before this court has insisted that 1733-2 represents an exception, represents some kind of loophole that in spite of a final judgment of the court of competent jurisdiction, a defendant in a criminal case who's still serving an unexpired sentence could collaterally attack that judgment. Under the plain language of 17-33, if it appears on the return to the writ that the party is in custody by virtue of civil process, defendant has never asserted that he's in custody by virtue of civil process. There's no contradiction. There's no inconsistency with 17-4.
But doesn't that ignore the first sentence? If no legal cause is shown for such imprisonment or restraint, or for the continuance thereof.
Right. Yeah, I'm certainly willing to let's address that. But I just want to point out at first, that's not the argument defendant raised in his habeas petition. It's not the argument he raised in his appellant brief. He switched to that provision only after the state pointed out that under the plain language of the statute, he's not entitled to relief under 1733 sub 2. Now, this clause memorializes a perfectly obvious proposition. A person can use habeas to challenge the legality of their incarceration. So if there's some question as to the legality of his incarceration or the continuance thereof, then the judge can inquire into the legality of the restraint, and if the restraint is proven to be unlawful, it shall discharge the prisoner. That provision is nothing new. That's what habeas is about. If the petitioner shows that his incarceration is unlawful, if the custodian of the prisoner can't show a valid basis for the incarceration, then the court is supposed to release the petitioner. But that's not the provision this defendant was relying on when he started this petition. When he started the petition, he was relying on this language about some act, omission, or event. That's the argument he made in his appellate brief when he's pounced on the rules of statutory construction. No provision can be ignored. Every word has to be given effect. This court can't change the language of the statute. The language of the statute says that provision applies only if the person is in custody by virtue of civil process. I don't think defendant has ever suggested that he's in custody by virtue of civil process. Now, there are 5 North Carolina cases that even mention this provision about act, omission, or event. One of them is the Supreme Court case in Harris. Harris was a case where the petitioner was in custody in a mental institution and filed some petition. Apparently, it was not a petition for habeas corpus, claiming that the person had regained their competency and they were entitled to a jury determination of whether they had regained their sanity. The trial court denied relief, and then the defendant sought review. And the Supreme Court, it was under a provision of the Civil Code, I think at that point, 35-4. The trial court had denied relief, and the Supreme Court affirmed that determination. And then the Supreme Court kind of mused that the way that a person would challenge their incarceration under those circumstances, when a person who is in a mental institution claimed to have regained their sanity, the way they should go about bringing that challenge is through state habeas. That's the situation where you would have an act, omission, or event that had taken place afterward, such that their continued incarceration, that is, on the basis of their mental instability, was no longer justifying their continued incarceration. The other cases dealing with that provision, Stevens, Hoffman, Freeman, and Leach, are all dealing with claims of entitlement of conditional release under parole board decisions. Leach is explicit about that. As a result, this is after summarizing the precedent, those cases, those 4 other cases. As a result, habeas corpus relief is not available in connection with an incarcerated individual's challenge to an administrative decision such as the denial of parole or the rescission of a parole contract, MAP contract, unless the inmate has exhausted available administrative remedies and unless some clear constitutional violation has occurred. Defendant is not claiming that there's any administrative decision that's denied him a right to conditional release. So even if this court's spin on that provision of 1734-2 carried any weight, and I say if because it does seem to be contrary to the plain language of the statute, but even if it did, this defendant is not entitled to proceed under it because he's not challenging an administrative decision of the parole commission. Defendant filed his petition for habeas corpus alleging that there was some inconsistency or that he was allowed to proceed under 1733-2, that COVID constituted some act, omission, or event. The trial court found the defendant was confined by virtue of final judgment of the court of competent jurisdiction. That order appears in the record at page 527. As I said a moment ago, that's precisely the same thing that happened in Surratt, and our Supreme Court affirmed the denial of habeas in that case. 17-4 sub 2 and 1734-2, which is the provision that applies after the writ has issued and a return has been made, say very clearly, relief shall be denied when persons are committed or detained by virtue of the final order, judgment, or decree of a competent tribunal of civil or criminal jurisdiction. That's not inconsistent with 1733-2. So under State v. Palmer and State v. Surratt, this court should find that the trial court did not err in denying defendant's habeas petition on the basis of judgment, the jurisdiction of the court that imposed the judgment. If there are no other questions.
I don't have any. It doesn't appear so.
That's about it. If I was in your position, I would ask the defendant just very quickly whether he concedes that he's not in custody by virtue of civil process, because if that's the case, then he can't get relief under 1733-2. I would ask the defendant if he concedes that he's not challenging a parole-related decision, because if he's not, he doesn't get relief under Leach, Hoffman, and Freeman. None of the 5 cases that mention this provision, not a single one, awards relief on this basis. Defendant has cited no North Carolina case, not a single one, that authorizes the kind of relief that he's seeking. It doesn't matter what Georgia is doing. It doesn't matter what New York is doing. There is no North Carolina law that supports the claim of relief that defendant is making. The state would respectfully request that this court find no error in the trial court's denial of defendant's petition for habeas corpus.
Thank you. Counsel for the appellant, I believe you have a little bit over 5 minutes.
Thank you, Your Honor. Your Honors, the state continues to try to reemphasize that habeas is only available to those under civil confinement. But we've seen, as the brief argues, time and time again, where that simply is not true. Writ of habeas has evolved and has expanded and has allowed people to challenge their conditions of confinement. Now, going back to the case law of North Carolina, State v. Leach isn't about challenging a parole contract. What State v. Leach is at its core was challenging whether a liberty interest had been created, and if that liberty interest was one in which could be challenged through the writ of habeas. And the court said yes, but that in this particular case, there has not been sufficient evidence or showing to carry that claim forward. And so Mr. Daw is in the same way that Leach, in the same way that Stevens and Hoffman and Freeman is challenging a liberty interest, and that liberty interest is a constitutional one. It is protection from cruel and unusual punishment. And so hence here, much as the same in Leach and all those other cases, Mr. Daw should have a right to be heard. He should have a, well, not in the sense that they remanded it back, but in the sense that he could challenge that liberty interest and that he has a constitutional and a statutory right to do so. And that's what we're asking the court to do here today. Because if this...
Could you please address the state's argument that you've essentially switched horses on appeal and taken a different part of the statute and argued that?
Sure, Your Honor, and I think the answer to that is because in writing the initial appeal brief, you look at the case law and you look at the statutes, and the argument that the state makes has simply never been made before. I haven't seen it anywhere else. If anyone's trying to make sort of a new interpretation, a new law here, it's the state. It's not Mr. Daw. It's not this case, because the state is trying to come up with a novel way to get out of this, because the only way that you would be able to deny our appeal is if in fact you read it their way, because otherwise the statute clearly allows it. But the Court of Appeals has already said 1733-2 allows this form of relief where a liberty interest is at stake. Now,
Counsel,
very cleverly so.
On that point, counsel, as you were addressing that for what the state said, it seems that the issue of lack of administrative remedies, can you touch a little bit more on that? I know Judge Jackson brought that up, and it seems the other cases have some element of administrative remedies being sought outside of the grievance that was filed. Has there been any other actions filed or taken by your client to then give to the scrutiny, like it seems to talk about in Stevens, to where you could get to judicial scrutiny once you've exhausted some administrative route?
And again, I go back to the fact that there just simply is no administrative remedy for this situation. I mean, who could have foreseen something such as the pandemic and the way it affects someone detained? Certainly not the statute, certainly not DPS's governance policy. So there is no way for someone in Mr. Daw's physical condition to challenge his confinement. And I would also point out that simply what the remedy here is his release. And that falls squarely in the corners of habeas. Habeas isn't seeking damages. Habeas isn't seeking an injunction. Habeas is seeking release because it is his custody which is violating his right to cruel and unusual punishment. The Second Circuit published an excellent decision, Bodine, which is part of our case law, and it does a really good job of collecting those cases and showing why a writ of habeas and not a writ of mandamus, not an injunction, not a 1983, when you are talking about conditions of confinement and someone's release, writ of habeas is the cause of action. It is precisely what it was meant to do. And so in that regard, that's why the writ of habeas is the proper remedy here. And again, there is no administrative remedy. There is no process for application to be released under ELC. It is something that DPS must do themselves. And so, but he has applied, and as of this date, at the time of filing, I think it only applied twice, maybe. By now, he's applied many more times. And so, in that regard, there simply was no administrative process because this was new. This was all evolving at the time of his petition. And so, but he's continued to try to do that. Your Honors, I see my time is running out here. And so I'd like to conclude by simply saying, if you hold to the state's contention, there will never be a situation, no matter how unconscionable, no matter how extreme, under which someone confined by DPS could ever seek relief by the writ of habeas, something the Great Writ was established for. Thank you.
Thank you, counselors, for your excellent argument. Mr. Soar, could you please gavel us out?
Yes, Your Honor. This session of the North Carolina Court of Appeals is now adjourned.
Thank you, everyone. Have a good day.
Thank you. Bye-bye.